Good morning, all. This pretrial review is in the matter of CFI 060-2023 and is being held by way of video conference before Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Reed Smith. Lead counsel is Mr. Rupert Reed KC. The defendant is represented by Clyde & Co. Lead counsel is Mr. Stephen Doherty. Thank you.
All right, well, thank you. Perhaps I'll go to you first, Mr. Reed. What matters should we cover today?
Well, Your Honour, you will have seen the position statements filed by the parties. I'm pleased to say there's a broad measure of agreement, including as to the issues that we need to cover in this PTR. By way of brief overview, and Mr. Doherty will add or correct, but I think it's possibly best to start with skeleton argument and length of the skeleton argument, then to look at the trial timetable, if we may, and then to deal with the issues of privacy or third-party confidentiality that will arise on the trial. And as I say, I'm pleased to say that I think the parties are not really very far apart at all, if at all.
All right, well, the trial, the skeleton arguments, I see AES proposed that there be a 60-page limit. Mr. Doherty, I think I saw something to the effect that you agreed with that or didn't dissent from it. Yes. Yeah, I'm content with that. I'm confident that with the parties and counsel involved, you'll sensibly use the pages, and I hope they'll be of considerable value to me. So
that's kind of, I mean, we felt it was important, not least, I mean, the 25-page limit applies equally to a heavy application with a 2-hour hearing, so for a trial, and given that as yet neither side has proposed written closings, this document will be hopefully an important document also in terms of guiding submissions after the trial is concluded. Noted, my lord, and I'm grateful. On trial timetable,
yes.
Again, the differences are pretty minimal, but essentially if we start with housekeeping, I think both sides are optimistic this can be dealt with in, say, 30 minutes. There is a constructive dialogue between the parties in terms of procedure and trial preparation.
Yes,
the only thing I've noted in my skeleton is that it can be really useful to the parties if there's access to the courtroom on the prior.
Yes.
Yes, I'm sorry. Not least, I don't think either party is familiar with the new courtroom, so that will be quite exciting for both of us.
Yes, I'm sorry. I meant to speak to the court officers before today, but I forgot. I suppose the only issue there is we're starting on a Monday,
yeah.
So there may be some practical issues, but perhaps what I'll do is that I'll speak to the registrar and the CPO and ask them to speak to your instructors and Mr. Doherty's and see what we can do. But yes, certainly I would like to accommodate you getting as prepared as possible before we start.
Yes. Yeah, and avoiding sort of technical hiccups on the morning is always a good way to start.
Yeah. Yeah. All right. Well, great. I'll just make a note that I'll contact the court staff about that. Yes. Okay.
On oral opening, I certainly don't think either side proposes to sort of go through traditional style, sort of turning the documents or anything of that nature. I think Mr. Doherty is slightly more minimalist than I am. I would prefer an hour, not least as my skeleton will be 3 weeks old by that point.
Yeah.
I will have some points to deal with in terms of Mr. Doherty's responsive skeleton, and in terms of just focusing on the causes of action, the elements of the causes of action, and what we're embarking on in my submission, that would be useful. I think Mr. Doherty has a slight preference for something shorter, but that is the extent of the difference between us.
Well, the attitude I take to it is that there'll be some flexibility in this. starting with, I'm hopeful that we won't need half an hour on housekeeping, but we'll
Yeah.
see. And then after that, really, I think whether I specify 45 minutes or 60 minutes, I'm not sure it makes a lot of difference. As you say, I will have the benefit of your written opening submissions, and I would take it that you will then use the oral opening to, in your case, deal with anything that Mr. Doherty has put in his opening that you think should be referred to, highlight any matters, and generally use the time without simply repeating what you've already said.
Yes. And subject to what we may say on privacy, it may be that there's no incentive for sort of jury speeches or sort of speeches to any third parties who may be. So that
I once, when I was a junior lawyer, saw an old-time judge, after he heard several jury-type speeches, tell the associate to go and switch the light on over the jury box and to point out to counsel there wasn't one. And I must say my attitude's a bit similar.
Good. Right. I suspect we're all in the same place on that.
Good.
Good. And then very briefly, the defendant is content to have only 2 days to cross-examine the claimant's factual witnesses and has helpfully suggested that time be redesignated to oral closings, and we're very happy with that.
Yeah, Mr. Reid, the timetable that's in the bundle, I think
that may already accommodate that. That I may just be reporting.
So. It provides, just look at it now, we've got on the afternoon of day one, evidence of claimants, fact witnesses. Yeah. Now, I'm proceeding on the basis that the way in which evidence in chief will be given will be by the witness verifying their witness statements, subject to, as always, if there are any corrections or for some reason or another, something needs to be qualified or added. But principally, essentially, the time put down as evidence of claimants' witnesses is the cross-examination time, isn't it?
Yes.
And
that's certainly the way that Mr. Doherty and I would be used to proceeding. Yeah.
And so we've got, yes, afternoon of day one, and then we've got day two and day three. Oh, no, we haven't. I see. We've only got half a day on day three.
That's right. And then we proceed to the defendant's factual witnesses.
Well, to some extent, again, I'm very much of the view that counsel within limits can run this. What I do want to avoid, well, I'll start that again. Counsel must, of course, use that time sensibly. And one of the things that I do want to avoid is the occasion which sometimes happens with less sensible counsel than you, that we have a situation at the end where one's counsel has not cross-examined on a topic and says no adverse inference should be drawn because it was they had only limited time. Any important issues are going to have to be dealt with. I'm not going to be attracted to the proposition that a significant issue was not cross-examined on because there was not enough time. As long as we all understand that, I'm content for the times that you're proposing to be allocated. And again, I don't propose to use a sort of strict chess clock time, but we need to keep to the timetable. And one matter that I might say right now. I think we've only got the 2 weeks. There's not, if we don't finish within that time, then we can't spill over to the Monday. Now, I don't want to be Pollyanna, but in looking at or meeting trouble halfway, as it were, these two things that I draw attention to. As a last resort, if we get to the position that we run out of time, I would adjourn the closing submissions. That is, so the evidence must be finished, whatever, and I hope and intend that we will finish the trial in total, including the submissions, but if anything falls, it'll be the submissions. Now, the second point is that if we start falling behind in the timetable at all, then I think I will be looking at extending the hearing hours to deal with that. So again, as long as we're all of the same mind, then I'm content with that.
My Lord, so Your Honour, that's certainly understood, and I think that would be the approach that both my learned friend and I are very used to.
Yes.
We're happy with the rule in Brown Dunn applying. These are serious allegations, and clearly these allegations have to be put to the relevant witnesses.
Yes.
Clearly it is important, I mean, not least from my perspective as claimants counsel, who will have to move swiftly from cross-examining to oral closing, that, you know, if we can make time, and indeed if there were time to have a pause between closing the defendant's evidence and closing, that would obviously, from my perspective, be hugely appreciated.
Yes.
But we're ready, and I think both of us feel that this is a realistic time estimate and to certify it accordingly.
Well, on that note, Mr. Reid, I am a fan of written closing submissions, and if it can be done, then I would like it to be done. Now, I know the timetable doesn't allow for a pause, but there were two things that I thought about that. The first is the one I think you just referred to, and that is if we can pick up time during the hearing, then we would take a pause to allow time before the oral closings. The second point is that knowing that I'm placing a burden on particularly those instructing and assisting you as well as you, I would think that it's a written closing submission is something that you can work on during the course of the hearing, particularly if you've got as I'm sure you will, a well-structured opening, then I would hope that you would have sufficient time and opportunity to be able to put something in writing together.
Yes. Well, my Lord, that's very helpful. Just in terms of timing, could I be clear? Your preference would be to have the written closing at or around the time of the oral closing, and not as a document 1 or 2 weeks later. Can I?
It would, but again, I'm flexible on this because I mean the pros and cons are obviously on the one hand, it assists me to follow and understand the closings if I've got your written submissions. And the other problem sometimes with written submissions afterwards is that it raises things that I'd like to ask you about and don't have the opportunity. On the other hand, the other side of the equation, of course, is that well put together written submissions are really valuable, and if it can't be done well enough before your oral submissions, then I would, in that circumstance, be looking at closing at written submissions afterwards, with always this possibility that if we went to, if that eventuated, and on considering your written closing submissions, there were things that I wanted to ask that I hadn't asked, then I would reconvene on video for that purpose. Now, again, I'm really wanted to leave it to a large extent to you to form a judgment as to whether, given the way the trial unfolds and whether or not you get time after the evidence closes to consider the case, for you to think about whether you can put together a helpful enough document to give to me during the trial, or whether it would be better to leave it till afterwards. That's perhaps something that, as far as I'm concerned, I'd be happy to assess as we go along.
Yes, one thing I've found in practice that sometimes works is for the council team to build up the skeleton. So that if they have started with something relatively skeletal, they are really sort of adding in the fruits of their cross-examination, building a composite document, but not essentially starting from scratch. And if your lordship can tolerate the repetition of reading some of the same material, then that sometimes works.
That doesn't bother me at all. Indeed, my preference is for a closing submission to stand alone. Now, if as a practical matter it is necessary for you to incorporate by reference what was said in opening, then so be it. But I suppose it's easier to look at one document than two.
No, what I had in mind was literally copying and pasting large sections of the skeleton. So, but
no, I'm happy with that. That's fine. It saves me doing it.
Thank you.
Just the only thing to add into that, Your Honours, obviously having agreed up to 60 pages on skeleton, we will have something slightly more detailed than perhaps we have the benefit of in some trials. And on that basis, it may well be possible that the parties are in a position to have a document at the end of trial. I suspect it might be one of those issues which we want to revisit towards the end of week one, when we see how things are shaping up and we see how the timetable is progressing, and take a view at that point.
It gives all of us an incentive to see that we try and get in front of the timetable, if anything.
Yeah, I mean, my sense is we're probably talking somewhere about 100 pages, but that's just a rough sense.
Okay.
Great.
What else?
Okay. The other major issue in terms of trial timetable is, and trial generally, is concurrent expert evidence. Your Lordship, I think, has helpfully provided a protocol.
Yes.
Which I think
you had a chance, Mr. Doherty, to look at that?
I haven't had the opportunity to discuss it with Mr. Doherty. And there's one.
Would you do it by committee?
Well, we're happy to do it now.
Yes,
my only reservations would be points. Well, firstly, having pointed out, I think it's Mr. Turner in point one, Daniel Turner.
I don't know where I got Daniel Harris from, but. Oh, I see. I've doubled up.
Yes.
Got Steve Harrison. Yes, all right.
And also by way of information, my understanding is that it's Mr. Church Morley who will be giving evidence in person. So he will be the expert, he's essentially the lead expert.
Will Mr. Harris be present?
He can be present.
I'm not. That was not either a direction or a request. It was just the way I'd read things that led me to think they were both going to be there. But I'm happy, and indeed, it's my preference that we not have
two
people if one will do.
Yes. Well, my understanding is that it will be Mr. Church-Morley who
Right.
will be attending to join the discussion. And then my only concerns would be in point 8 with the experts together giving a brief overview, and 11 where the experts can each intervene or interrupt on their own initiative. And I don't know well the personalities of, I know Mr. Turner, I don't know Mr. Church-Morley well, but I just wary of the danger of overspeaking and a sort of dominant personality imposing themselves. And in those circumstances, I would, Your Honour, merely facilitating, maybe it may require some more direct chairing from the court.
Yes, I used the word facilitating to cover a multitude of possibilities. The way I envisage the matter going, and frankly, I'm not yet familiar enough with the evidence to be able to go into detail, but my intention is to go to the joint expert report, the joint statement. My first look at it, well, perhaps I might say this, at first and very superficial glance, led me to the view that there's quite a few statements where the witness is essentially saying it's a matter of what the assumptions or instructions are, which list they should be operating from. And that, having been said once, I suspect deals with the matter. Then when we start to get into their matters where they have different opinions, my provisional intention is this, that I would ask one or other, usually in turns, about a particular topic that's raised in the joint statement, and ask for him to briefly explain his position, ask the other to briefly explain his, and then ask each of them whether they have anything to say about what the other has said. Now, as to the point you make, Mr. Reid, that's something which I intend to wait and see. If there was any element of one being domineering or becoming unruly, then we'd have to have more of a schoolroom approach to it. But the intention is that, well, my intention is that I want to know what each of them has to say about what the other says, and that generally, I must say, my experience is that with professional witnesses, they tend to be fairly sensible about it. And of course, the best outcome is when they actually get rather cooperative in it, which sometimes happens. So again, I think this is something which a little bit, it's a matter of see how it goes. I certainly don't intend to allow one person to dominate. And I also, the other occasional experience I've had, which I hope doesn't occur, is that somebody becomes too accommodating about everything, and I don't really end up with the benefit of what they really think. So what I'm really saying, this is again a case for flexibility in saying, in putting out that, well, sorry, I'll go back on that. What I intend to do is to, at the beginning, explain to the witnesses the approach that I'm going to take, the procedure that we're going to follow, and to explain to them that the reason for inviting or giving them the opportunity to comment on the other is just so that I can make sure that I've heard what each of them has to say. It's not my intention that there should be an argument going backward and forth about it. And again, sorry if it doesn't really resolve the matter, but it's something which I really want to see how it unfolds, but I should have the opportunity to ask one witness to comment on the other. As to your point about them taking the initiative, I propose to say to them that I want them to indicate if they want to say something before they say it. You remember the Lord of the Flies? We won't have a conch, but I don't intend people over talking. If one of the witnesses wants to comment on what the other has had to say, then I want them to tell me that they want to say something, and then I'll see whether it's appropriate that they do so, and if they do so then. For example, it would not be appropriate most of the time in the course of cross-examination for one witness. Occasionally, and it's a matter for you, I've seen some counsel in the course of cross-examining the other side's witness will ask their own witness to comment upon it, an answer, and I'm content with that. It's in your hands, and I permit that. But whilst you're cross-examining, you've got control of it. Whilst I'm facilitating, I will let the witness know if they want to comment, they're to let me know, and I'll deem whether they should or shouldn't. Is that helpful?
That's been very helpful as an expansion on facilitation.
Yeah.
And with that more activist approach, then I'm certainly content with that, subject to anything my learned friend may have to say.
Mr. Dougherty, what do you want to add to that?
No, not particularly anything to add. The protocol is helpful. It accords with, I think, the discussions we had about this at the prior CMC, so nothing necessarily came as a surprise. I think probably the only thing to look at is apportionment of time that we've provided in the timetables to see if that broadly fits with Your Honour's expectation.
How much time were we allowed?
So the experts would begin their evidence on day 7, so it's page 111 of the PTR bundle. So that's the direct presentations, which we had budgeted anyway prior to the protocol being received, followed by the beginning of the concurrent evidence, which would then follow into the next morning, followed by a period of cross-examination, which I think is allowed 90 minutes per party on the 5th of March.
Yes. Yes, I see. So it's allowing, we've got an hour and 40 minutes for the, if I call it, facilitative session, and then you've got, what do you say, an hour and a half each for cross-examination.
I suppose there may be an issue, given the procedure you've outlined, as to whether the direct presentation before the, whether that really adds very much.
Yeah, one thing that I am, that I do want them to explain to me, as I mentioned in the protocol, is for them to explain to me how their model works, for the reason that there will probably, may well be, that I'll mix and match, or even in some occasions take a different view of the inputs than either of them. And I want to know how I can then plug the inputs into the model to come up with the answer.
My experience is there are 3 approaches. Sometimes it's the flexing is relatively easy. It's just a question of taking something out or dividing by something. It's a single function. Sometimes changing one input affects other inputs, and it becomes much more complicated.
Yes.
And you therefore get a judgment where the court essentially gives its findings on the various issues, and the expert then needs to go in and rework it by reference to those findings, which has the risk of a further hearing.
Yeah.
Or sometimes it's possible for the experts to produce a model that can be flexed by the court with fairly simple instructions. So perhaps that's something.
It was the third one that I was hoping was the position. And perhaps that's something, I'm grateful for you raising that, Mr. Reid, which perhaps you instructors can raise with the experts in advance. That would be helpful if they can both have and show me a model that allows that.
Yes, well, we will investigate that on our side.
Yeah, the other possibility, which I've used sometimes, is that after I've, as it were, decided on the inputs, I then ask the two experts jointly to work out the answer. But I think that usually arises in more complicated cases than this.
Yes.
My expectation is that this is not going to be a terribly complicated model, but I might be wrong on that.
Yes, we will see if there is a model that can be flexed by the courts. But we too would hope that if not, it can be done by agreement after a judgment, if necessary.
Well, that would be most helpful if you do raise that with the experts, and you can tell me the position either in your opening submissions, and you can add a page if you need to do that, or if necessary in your opening submissions, and then oral submissions, in the hope that it's not going to be terribly complex to explain which course.
My lord, yes. Your Honour, the only other thing on expert evidence is the expert forensic IT evidence of Mr. Smith.
Yes.
My understanding is that there isn't an expert for the defendant. I don't think it's proposed that there be any cross-examination of Mr. Smith. So the issue is what if any attendance is required by him. If he's required to attend, to give the oath and to put his evidence on record, then we would ask that he do so remotely, and be spared the time and cost of
what
attending.
Mr. Reid, has he signed a witness statement verifying?
Well, he signed an expert's report, essentially discussing the claimant's devices which have been recovered, imaged, and he looks at what documents, etc., they've examined, and the client list, etc. So I don't think it's hugely controversial. It doesn't seem to be. There's no evidence has been filed by the defendant on that issue. So in those circumstances, if he is to be sworn, we would ask that he can do so remotely.
Mr. Dougherty, what's your view on that?
I think we're on the same page. As Mr. Reid said, it's not a hugely controversial report. It lays out some factual position, which I think are really points to submissions than anything else.
Stody, the qualification not hugely.
I've seen
an element of doubt.
The defendant's way that we proposed to deal with that evidence is to deal with it in submissions. There's not anything to ask. The defendant's expert is probably a matter for the court as to whether Your Honour wants to call the witness for the purposes of swearing their evidence, or whether the report is taken as read.
I don't require it if the defendants don't require Mr. Smith.
Mr. Smith.
Mr. Smith, if the defendants are willing for his report to be admitted into evidence without him appearing and swearing it to it, then I don't require it.
I'm grateful. Yes, and the final thing from me in respect to trial timetable is oral closing, and we would just want to be clear that with each side having a day for oral closing, we would want an hour at the very end just to reply to any points, and they would be reply points arising on Mr. Doherty's oral closing.
Yes. So let's look at that again. Okay, so the timetable provides that I see. So we've got Thursday, Friday. Well, again, I think we'll be flexible about this. We'll see how we go. It might be that we start a little earlier on the Friday, if necessary, to get that time in.
Right.
That's
it may be that I wouldn't need it. I wouldn't speak for an hour for the sake of it. I would, if it was possible to do it in 15 minutes, 10 minutes, 15 minutes, I would do so.
Yeah. But it might be that we would start at, say, 9:30 to give some flexibility, and the hope that you'll need half an hour or less. But if you want more, then we'll have to sit on for a little later.
Yeah.
Another point whilst I'm on that, I see we've got various breaks. I see some of them have got times next to them. I think you said in somebody's letter that you envisage a morning and afternoon break. Is that right?
From my perspective, yes. I think that would be helpful.
Yes. So that's on the basis that we'll be going from 10 o'clock. That for the most part, I think some of them might vary, but for the most part, lunch will be taken at 1 o'clock. Is that the expectation?
Yes.
For 1 hour, resuming at 2, and
yes.
then concluding at, for the most part, 4:15.
Yes.
Is that? Yeah. Okay. Well, on that timetable, I'm content for there to be a 15-minute break. When it be taken will of course depend upon what's happening, and my position is to invite counsel, if whichever counsel is examining at the time or speaking at the time, to choose the appropriate time to take the break, and leave it to you, albeit I might remind you if it looks like we're going on a bit. Are you content with that course?
I'm content, Your Honour.
All right.
Yes, Your Honour.
All right. What else?
Well, I think from my perspective, in terms of trial timetable and trial generally, that's all I have, and which brings us neatly on to the issues of privacy and third-party confidentiality.
Okay.
Clearly, you want to be aware that there is one can have a slightly queasy feeling reading the documents. It's, certainly for those of us like my learned friend and I who've worked in Dubai a lot, you start to recognise names and very sensitive financial information relating to people who are known in Dubai, and both parties have an obvious interest in maintaining the confidentiality of their clients, given the sensitivity of the financial information that is being discussed in a number of the documents. Another friend will interrupt if I misspeak, but my understanding is that we're broadly agreed that there should be privacy of the hearings, so they shouldn't be live streamed, and we shouldn't have members of the public or students watching the proceedings, but that both parties feel strongly that the judgment should be public, given the nature of the allegations which we make and which we stand by, and which the defendants resist. And so the judgment should be public, but that if there is a need in the course of the judgment to discuss individual client cases, that reference should be done by initials or acronyms.
Yes.
There has been a
Yes.
schedule produced. We may be able to simplify it further. So essentially, the initials and possibly one and counting. I think the existing schedule gives them a code by reference to the last 3 digits of their account number. That we may be able to simplify it further.
I'm not keen on that, I have to say, Mr. Reid. Initials I might be able to deal with, but code numbers for people I find a bit difficult.
Well, they're very popular. There seem to be 8 or 7 MBs, for example. So we may need MB1 to 7, MB1, MB2, and so on. And that would give a degree of protection both to those clients and hopefully to the parties.
Yes. I'm not sure if you're aware, Mr. Reid, but I did deliver a judgment on the contempt hearing in which there are various clients referred to, named.
Yes. I don't think either side is suggesting that third-party confidentiality has been waived or that. And I think we would maintain that our strong preference would be that in the judgment, if and insofar as is necessary, and suggestion it may be that if it's necessary to refer to particular clients, that be done by way of initials. I think both parties would be happy with that as a sensible degree of protection.
Mr. Doherty, are you content with that?
Yes, Your Honour. I think that the position with the committal application was we heard it in private with a view to seeing if there was anything particularly private came up. And I think that Your Honour was cognizant when preparing that judgment that it shouldn't contain particularly sensitive information unless it really had to. I suppose the position is maybe slightly different in respect of trial insofar as there are a far greater number of individuals than there were with the contempt allegation. So it may well be that the ciphering system is the easiest way to cut through that. Precisely what the most straightforward list of initials might be, we can look at. But as a matter of principle, it feels like a sensible way of proceeding, which is not going to, most importantly, interrupt the flow of the trial itself.
As to during the hearing, there is no reason why names should not be used then, is there?
No, if the hearing is in private, if the trial is in private, well, I think the scenario that Mr. Doherty was particularly concerned about was where the counsel, knowing that they were going to raise the issue of a particular, required a privacy order there and then, which would require the court to be cleared and uncleared, and that can become intolerable in terms of wasted time. So, regrettable as it is, I think the conclusion we both reached is that the trial needs to be in private to avoid that problem.
I'm content with that, Mr. Reid.
I'm grateful. And then there was a further issue in respect of what have been referred to as the FTI documents. For your Lordship's information, my understanding is that there was an inspection by Mr. True yesterday of those documents, and that there's agreement that one document shall be included in the trial bundle. So I'm relieved and pleased to say that we don't need to trouble Your Honour with that.
And there's no difficulty about whether Mr. True can seek instructions from his clients about it, is there?
I don't think he wishes to, save in respect to the one document, and there has been agreement that one document should be disclosed to the client and should be in the trial bundle. I'm just going to check that I'm right in saying that. Yes.
All right.
So, Your Honour, that
apologies, Mr. Reid.
No, my apologies. That concludes all the issues that I have on my shopping list. If Mr. Doherty has any further.
Yes.
It was just one practical issue connected with the hearing proceeding in private. Of course, the trial is not going to be live streamed and it's not going to be on YouTube, for example. There are likely to be individuals who wish to follow the feed. So, for example, I'm thinking of Mr. Turner, should he wish to see the parties' openings. Presumably, the parties would agree that a link to the hearing would be made available to actually those who are expected to attend hearing. So it would be a defined list of email addresses, presumably, so that experts who will be in person at trial but will be elsewhere for parts of the trial will still be able to follow it.
Well, if the parties agree that a particular person can attend, again, I'm happy to go along with that.
Your Honour, that makes perfect sense in my submission.
All right. Anything else, Mr. Doherty?
I'm checking my note, but I think that's everything.
All right. I've got one request to make of the parties, that sometimes it occurs that there are some key documents that are going to be referred to repeatedly. I don't know if this is such a case. Where there are, I'm aided by having a hard copy of those, what I refer to as key documents. So I would ask you to give some consideration to that. And if there are some documents that you are going to, that you refer to with more than usual frequency, then please put a bundle of them together and provide a hard copy for me at the beginning of the hearing.
My Lord, yes, we will seek to avoid a battle royale as to
Yes.
getting each side trying to get their favourite documents into the core bundle. But
Yeah.
that just reminds me.
Can I tell you that this core bundle, again, I mean, you're both familiar with it. I'm not a jury. All it's going to do is this, that instead of me looking at the screen, I'll be looking at the hard copy document when somebody refers to it. It's not going to give it any special status.
Your Honour, yes. Just while we're talking about hard copies, I would normally, speaking for myself, being slightly old-fashioned, have hard copy pleadings bundle, witness statement bundle, and experts bundle, and I would probably have it spiral bound A4 double-sided. If your Lordship has any particular preferences, if there's anything we can do, the parties can do to assist in terms of ensuring that your Honour has the bundles as you would like them, and if it would be most convenient to you, then either speak now or let us know.
I'd be grateful if it were for a copy like you're getting, Mr. Reid.
Your Honour, yes, we will see to that.
All right. All right. Anything else that you can think of? No. If something should come up, please raise it sooner rather than later, either with the registry, or if it's necessary to come to me, I will be available between now and I think it's 24 February, is it, that we're starting? Some date like that. So please raise it if there are any matters that need to be sorted out. I'd rather it be raised beforehand rather than on the first morning of the trial.
Your Honour, yes. Your Honour, would Your Honour want us, my learned friend and I, to prepare a minute of today's?
Yes, please. Yes,
Honour,
please.
Yes.
Most grateful.
Of course.
All right. Well, thank you. That then concludes today's hearing, and thank you for your help.
Your Honour, we're grateful. Thank you.